The federal government insists prospective couples wishing and planning to contract their marriages at the Ikoyi Marriage Registry or any other federal marriage registry under the Ministry of Interior are free to do so, saying the 1999 Constitution legally empowers it. This position is despite the recent judgment of the Federal High Court, which restricts marriages formalized at federal registries to only Lagos and Abuja. Kemi Folademo has more.
The December 8th, 2021 judgment was premised on a 2018 suit filed by 4 local governments in 4 states. They were seeking to stop the federal government from further contracting, celebrating, issuing marriage certificates, or registering marriages, as well as issuing licenses to marry under the Marriage Act. The first applicant in the case was the Etiosa Local Government Council in Lagos State. The 3 others were the local government areas where the federal government established some federal marriage registries. They sued the Minister of Interior and the Attorney General of the Federation. A firm, Anchor Dataware Solutions Limited, was later joined as a third defendant by an order of the court in 2019. The applicants also wanted the court to direct the Interior Minister to transmit or return all marriage certificates issued within their local government councils. Subsequently, after a 2004 judgment by Justice Oyindamola Olomojobi of the same court, which gave local government registrars exclusive authority to register marriages under the Constitution, Justice Olomojobi also held in the 2002 case that lawful bodies which can celebrate marriages for intending persons shall include registrars in the Ministry of Internal Affairs, Director General of the state government, or any officer in those ministries, and the Minister of Internal Affairs. Justice Daniel Osiago, in assuming jurisdiction on this latest case, unlike a previous judge of the same court who struck out the suit in 2018 for being an abuse of court process, said that the issues raised in the 2004 judgment dwells on whether only local governments are to contract and register marriages, but the court says that this case deals with other issues. Among the issues which the court determined in this present case was whether the federal government, through the Minister of Interior, should have established federal marriage registries in Edo, Imo, and Rivers State within the jurisdiction of the aggrieved local council areas. Well, Justice Osiago held that any such federal marriage registries established outside the former Federal Capital Territory of Lagos and the present one in Abuja is, quote, an exercise in futility. But the court recognized what it calls the exclusive powers of the minister to grant licenses to places of public worship to contract marriages all over the Federation. Justice Osiago said neither the 1999 Constitution nor any other statutes abrogated the existing federal marriage registries in Lagos and Abuja. As of 2019, the ministry named 12 federal marriage registries in 11 states, and in May 2021, the federal government announced the creation of 20 new registries in its bid to establish such registries in all states of the Federation. But in reaction to this latest judgment, the Ministry of Interior says it has powers under extant laws, including the Constitution, to conduct marriages at the Ikoyi Marriage Registry in Lagos or at any other federal marriage registry. On the other hand, couples who contracted their marriages at the Ikoyi Registry or intend to are now relieved at the legality of their unions there. But keen observers advise the federal and local governments to seek further intervention on the matter from a superior court.
This particular court have equal and coordinating jurisdiction, and because of that, the present judgment cannot invalidate what had earlier been declared by the same court. All the parties, I will appeal to them, let them appeal to the appropriate higher court, that is to say court of appeal, and let people be rest assured that if you had done your marriage at the federal marriage registry, it is not tantamount to invalidity or nullity of that particular marriage.
Another takeaway from the 2004 and 2021 judgments is that marriages conducted at the local governments aren't inferior to those done at the federal registries. But sentiments captured by TVC News in Nigeria's commercial capital reflects why people opt to formalize their weddings at the Ikoyi Federal Registry.
With federal government, I don't think there will be any mistake. So I've not heard anything that is negative about the place. It's still on, and it's approved by the federal government.
I prefer the federal government, because federal is federal, and it seems that it is more recognized everywhere, Although when we contracted our own some 30-something years ago, it was at the local government level, but I wouldn't do that for my kids now.
As the controversy lingers, the federal government says it will consider its options, while regular marriage activities will continue at all its registries. Kemi Foladiemo, TVC News, Lagos.